Thank you for that. So, ladies and gentlemen, we have an exciting lineup for you today, a lineup including experts from academia, practitioners, and lawyers who are all very adept in the field of international trade law. My name is Satvik Shekhar. I'm a legal consultant and an assistant professor at Center for Trade and Investment Law, and I'm the moderator for today's session. We are delighted to be joined by five exceptional experts in the field of international trade law. Uh, uh, we have Dr. Edwin Vermust, who is a founding partner at VVGB Abdulkatin Law Firm in Brussels and is also a faculty at World Trade Institute Bern. He's been practicing international trade and EU law and policy since 1985. He's been involved in virtually all major EU trade defense cases and is generally considered to be one of the world's leading experts on anti-dumping, subsidies, and safeguards. We welcome you, Dr. Vermust. We also have with us Professor Abhijit Das. He is the head and professor at Center for WTO Studies. Professor Das is a trade policy expert who combines extensive experience of international trade negotiations with formulating, implementing, and managing trade-related capacity-building projects as well. He served in the government of India for 21 years and headed the UNCTAD India program from 2007 to 2010. We welcome you, Professor Das. We have Ms. R.V. Anuradha. She's a partner of the trade team at Claris Law Associates, a wonderful trade law firm in New Delhi. She heads the trade team at Claris and advises clients on compliances and governments on negotiations as well. She has also made representations at disputes at the WTO and other FTA forums, and will be exciting to have her share her experiences with us on the topic. We welcome you, Ms. Anuradha. Dr. James Sandampara, he's also joined us as a panelist. He's the head and professor at Center for Trade and Investment Law. He has several years of experience in the field of international trade and economic law and has worked with leading law firms, corporate firms, and also UNCTAD India's program before joining academia. He also appeared on behalf of Indian delegation at the WTO appellate body proceedings on the avian influenza dispute. At CTIL, he advises the government of India on various aspects related to international trade and investment law. We welcome you, Dr. James. And lastly, we have Dr. Wei-Huan Zhu, who is a senior lecturer at UNSW Law, University of New South Wales in Sydney. He focuses on the laws of the WTO, customs law, especially trade remedies, FTAs, Chinese commercial law, China's regulations of international trade and investment, China's integration into the international and regional economic order. He's published widely on these topics in a number of top international and domestic journals, such as the Journal of Economic Law, World Trade Review, Journal of World Trade, etc. So a very warm welcome to Dr. Zhu as well. So I will very briefly let everyone know that this is a 90-minute long session with 60 minutes reserved for the formal discussion among the panelists, with each panelist speaking for around 12 to 15 minutes. And we will take the questions from the audience during the last 30 minutes after the panelists have shared their views. Now, jumping straight into the session, I'd very quickly give you a brief about the state of play with respect to subsidies at this point of time. A few countries have proposed to relook at the SCM agreement and revise the subsidy regulatory landscape. While the US, the EU, and Japan have sought to add new types of prohibited subsidies, the EU has released a white paper on foreign subsidies or transnational subsidies, a topic which may have consequences beyond trade. The scope of International Working Group on Export Credits is also contentious at present. These proposals stand to take subsidy disciplines into uncharted territories, and the panel will discuss the legal, trade, economic, and maybe also geopolitical implications of these proposals. With this, I would like to open this panel discussion by inviting Dr. Edwin Vermust to present his views on the recent EU practice on regulating third country and importing country subsidies. The main question which we would like to hear Dr. Vermust's thoughts on is that does the EU white paper and the CVD investigation against the Chinese company in Egypt have far-reaching consequences on the flow of FDI from non-EU countries to EU? And if that is the case, how can we expect EU to strike a balance between regulating foreign subsidies and FDI flow? Dr. Vermust, I request you to share your thoughts with us.
Okay, thank you very much. So as Satvik has said, and as probably all of you know, subsidies has become a very hot issue in the WTO and also in the national practice of WTO members. And I would say that after some initial hesitation by the EU, probably because there are a lot of subsidies in the EU itself, but that hesitation has been overcome by the EU authorities. And as the title of my presentation indicates, the EU these days is expanding almost every day the scope of its anti-subsidy practice. And I will give you two examples of that. Next slide, perhaps. Next slide, Sadvik. We can make a distinction between third country subsidies, and I put subsidies between quotation marks, and importing country subsidies. So this is, I think, a crucial distinction: third country subsidies and importing country subsidies. This goes beyond the traditional scope of especially countervailing duty measures. And I think it's fair to say that the EU has taken and is taking the lead with respect to both. So what is the case for third country subsidies? I first explain the situation quickly and then I go in more detail. For third country subsidies, we have a country, for example, China. At the moment, these cases are limited to China, but undoubtedly it will be expanded to other countries. So at the moment, we have China. Then we have a subsidiary of a Chinese company in a third country. In the EU thus far, Egypt and Indonesia. And then the product is exported from the third country to the EU. So that I call third country subsidization. Next slide. The other side of the coin, so to speak, is importing country subsidies. And there you would have, for example, China or India or Russia for that matter, which is supposedly subsidizing a Chinese or a Russian or an Indian company which has settled, which has established in the EU, or which has business in the EU. So this I call importing country subsidies. Next slide, please. So if we go to the first case, if we go into a bit more detail, the first case where this issue came up was a case involving glass fiber fabrics from China and from Egypt. So it was a case against two countries. It was actually a dumping and a subsidy case, but I'm focusing on the subsidies, obviously, today. And what was the situation there? There was a Chinese company, Yushi, which had set up a factory in Egypt in the Suez Economic and Trade Cooperation Zone. And the company was exporting the glass fiber fabrics, both from China directly to the EU, but also from the factory in Egypt to the EU. So there were three types of subsidies here. There were subsidies given by China to the company based in China. There were subsidies given by China to the Egyptian company. And again, subsidies I put in quotation marks because I don't think they are subsidies within the meaning of the SCM agreement, as I will explain. And then there were subsidies given by Egypt to the Chinese company based in Egypt. So I'm focusing only on the subsidies given by China, allegedly, to the Egyptian company of these glass fiber fabrics. And there were three types of subsidies. They were all basically financial subsidies. First, and you see that at the bottom of the slide, there were loans received by the Egyptian Chinese producer directly from Chinese financial institutions for its establishment in Egypt. Second, there was financing of the intra-group loans between the Chinese parent and the Egyptian subsidiary. And this, of course, is a fairly common practice, right? If you have a mother and a subsidiary company, normally the subsidiary will be financed by loans taken out by the mother company. And third, there was financing of the capital investment in Egypt by the Egyptian company, by the Chinese parent. So these were the three types of subsidies that were alleged in the complaint and that were investigated by the EU authorities and that were found to be countervailable subsidies. Next slide. What was the logic of the EU? And obviously I don't agree with that. I'm just giving you the logic of the EU first, right? So what were the EU arguments? Well, they were based on Article 11A1 of the SCM agreement, coupled to Article 11 of the ILC, the International Law Commission's articles on state responsibility. And it relied, in fact, very heavily on that Article 11. So in terms of looking at the financial contribution, the EU found that Egypt had acknowledged and adopted, those are the key terms, Egypt had acknowledged and adopted the financial contribution granted by Chinese public bodies as its own through political declarations and cooperation in this Suez Economic and Trade Cooperation Zone. Second, in terms of the benefit, again, the fact that Egypt had acknowledged and adopted the financial contribution by Chinese public bodies included the benefit element, and therefore the benefit was calculated on the basis of out-of-country benchmarks, as the EU normally does to quantify subsidies given in China by the Chinese government or by Chinese public bodies. In terms of specificity, Egypt had acknowledged and adopted China's designation of the Suez Economic and Trade Cooperation Zone as an overseas investment territory through the cooperation agreement. Again, this is according to the EU. And as the subsidies were limited to companies operating in the Suez Canal zone, of which the SETC zone is a part, therefore the preferential financing was a regional subsidy falling under the jurisdiction of the Egyptian government. Satvik, next slide. Since this case, there have been two other cases where, again, third country subsidies have come up. And the first case was a case involving subsidies given to filament glass fiber, again, in Egypt. But here the distinction with the previous case was that this case only involved Egypt. There had already been a previous case involving China, but this case only involved Egypt. So it was a separate investigation for Egypt. And in the middle of the investigation, the EU changed course, supposedly because of what happened in GFF. And they decided to also treat as countervailable the three types of subsidies that were found to be countervailable in the previous case, in the GFF case. Obviously, there's a close link between GFF and GFR. And in fact, the producer in Egypt, it was the same producer. It was also Yushi. So it involved the same producer. Then a third case, a completely different product, stainless steel hot roll products. This was a case against China and Indonesia. And here we had a Chinese producer who was producing in Indonesia. And again, supposedly they were benefiting from subsidies given by Chinese government or Chinese public bodies. This case is still going on. And in fact, it looks like it will be terminated because the complainant Eurofair has withdrawn the complaint recently, so there will probably never be findings published, because if the complaint is withdrawn, the EU does not really publish detailed findings. But the fact that it was considered here and that it was investigated here makes it the third case in which the EU was at least intending to act against third country subsidization. Next slide. Now, I'm going a bit more into the legal points from our perspective, from my perspective. And then the question is, where in fact is the subsidy within the meaning of the SCM agreement, right? Not all subsidies are countervailable or are treated as subsidies by the SCM agreement. Only certain subsidies are treated as countervailable by the SCM agreement. So the SCM agreement sets the scope of what is a countervailable subsidy. Now, if we look at various articles of the SCM agreement, in my view, it is quite clear that this third country subsidization was never intended to fall within the scope of the subsidies of the SCM agreement. So let's start with Article 11A1. It says, for the purpose of this agreement, a subsidy shall be deemed to exist if there is a financial contribution by a government or any public body within the territory of a member. Now, we've had some discussions on this in previous webinars, including a webinar hosted by the Indian Institute of Foreign Trade. And there, some other participants took the view that the term a member is an open term. So therefore, it does not preclude third country subsidization, acting against third country subsidization. I have two counter-arguments against that. First of all, the appellate body report in USAD and CVT China, you see it on the right-hand side, where the appellate body distinguished between government in the narrow sense, which comprises formal agencies or departments of the government, and government in the collective sense, which includes public bodies and private bodies entrusted or directed by the government. So in my view, this concept of government in a collective sense sets the limit to the entities whose conduct can be attributed to a specific WTO member. And by definition, it excludes the possibility of attributing conduct of one member to another member. So that's my first argument on the basis of Article 11A1 of the SCM agreement. Secondly, if you go to the bottom of that agreement in Article 11A14, you see that the very last word there is governments. So it's a plural term. It's the plural term of governments. So if the intention had been that you could attribute the conduct of one member to another member, I would say that the drafters could have easily in Article 11A1 also said members instead of member. So that's my first point. Then if you go to other articles of the SCM agreement, and I won't go into too much detail because of time, but you see each time the term coming up within the jurisdiction of the granting authority, or in the territory of that member, or within their territories. And finally, in Article 15b of China's accession protocol, there is a sentence which says that in applying such methodologies, the importing WTO members should adjust such prevailing terms and conditions before considering the terms and conditions prevailing outside China. So again, this implies that you stick to the territory of China to determine whether the Chinese government is giving subsidies. Next slide, please. Then, very quickly on Article 11 of the International Law Commission's Articles on State Responsibility. This article provides that conduct which is not attributable to a state under the preceding articles shall nevertheless be considered an act of that state under international law if and to the extent that the state acknowledges and adopts the conduct in question as its own. So here you see, of course, where the EU takes the term acknowledges and adopts from. It comes straight from Article 11. And while Article 11 of the ILC articles can be used as an interpretive tool under Article 31.3c of the Vienna Convention on the Law of Treaties, the questions still are, is it a rule of international law, Article 11? Is it relevant? And is it applicable in the relations between the parties? So in my view, even if Article 11 can be at best used as an interpretive tool, it cannot be used as a means to expand the scope of the SCM agreement. And because the SCM agreement is clear, in my view, you cannot use Article 11 to expand its scope. Next slide. Okay, then we go to the other side of the coin, the importing country subsidies. And this is the white paper that Satvik has mentioned. First of all, I should explain that it's just a white paper at this stage. So this is the basis for discussions. The proposal, in a way, it's not even a proposal, it's a white paper. There will be discussions between the European Commission, which has drafted the white paper, the European Parliament and the Council, the European Council of Ministers, to discuss further whether this white paper, the ideas in the white paper should come to fruition and in what form. So it's just at this stage a white paper. That's a very important point to bear in mind. And as the EU decision-making process is excruciatingly slow, normally it will take probably still a couple of years before this law, if it becomes a law, ever enters into force. But still, some of the ideas here are very far-reaching and I would say very dangerous and very discriminatory when compared with the state aid regime that we have for EU companies. So the white paper makes a distinction between three modules. They are called modules in the white paper. Module 1, which is probably the broadest in scope, addresses foreign subsidies that cause distortions in the EU market and that are provided to a beneficiary that is established or in some instances active in the EU. So establishment is not strictly necessary. Activity in the EU may be sufficient to have this module apply. If these subsidies are found, and it is not difficult for the EU to find subsidies, especially where China is concerned because of the methodology, which relies very heavily on out-of-country benchmarks. And if those subsidies cause distortions in the EU market, distortions, I think in very simple terms, we say cause injury to EU producers or they distort the level playing field, then what are the measures that the EU can impose? There's a whole bunch of them. For example, they can force the company to divest certain assets. For example, they can prohibit certain investments. They can prohibit a subsidized acquisition. They can impose third-party access, for example, for mobility apps for providers of transportation services. They can force the company to license on fair, reasonable, and non-discriminatory terms. They can prohibit certain specific market conduct linked to the foreign subsidy. They can force the country to publish certain R&D results in a way that allows other undertakings to reproduce them. And they can tell the company to pay back the subsidies that they received, not to China, but to the EU or to the EU member states. In the context of state aid, if Ireland gives subsidies to Apple, and if it's found that those are in violation of the state aid rules, Apple has to give the money back to Ireland, which is the government that gave the subsidy, right? But here, if you have a Chinese government or the Indian government that is found to give subsidies, the money would not go back to China or to India, it would go back to the EU or to EU member states. So that's quite a distinction, I would say. If we go to the second module in the next slide, Satwik. The second module is much more narrow in scope, and it is intended to specifically address distortions caused by foreign subsidies, facilitating the acquisition of EU targets. So module 2 only deals with acquisitions. But again, the redressive measures possible under module 1 would apply here too. And in addition, the acquirer may offer adequate commitments to remedy the distortions caused by the foreign subsidies, which the competent supervisory authority would then make binding on the acquirer in its decision if it considers them effective. So this deals only with foreign acquisitions. Third module, next slide, Satik. The third module deals with public procurement, and it provides that foreign subsidies can be addressed in individual public procurement procedures, and EU public buyers, so the institutions that do the tenders, would be required to exclude from public procurement procedures those economic operators that have received distortive foreign subsidies. What is the redressive measure here? To some extent, it's already indicated. The economic operator benefiting from the subsidy would be excluded from the public procurement procedure in question. But in addition, it would be possible to exclude that economic operator from future procurement procedures for a maximum of 3 years. So I think this very short explanation makes clear that the white paper, if it comes to fruition, is extremely far-reaching and is discriminatory vis-à-vis foreign suppliers as compared to EU producers, which are subject to EU state aid rules. To give you one more example, and I will conclude with that, in the EU state aid regime, there are many exceptions for subsidies which are basically allowed. And these mirror, at least to some extent, the green list subsidies in the SCM agreement that have lapsed. But in the SCM agreement, they have lapsed, right? So they're no longer available. In the state aid regime of the EU, they are still available, but they would not be available under the white paper because the white paper relies on the regimes, on the definition of subsidies in the SCM agreement. It does not rely on the subsidies in the state aid regime of the EU. So I leave it there. Thank you very much for the invitation.
Yeah, thank you, Dr. Vermust. It was wonderful to hear your thought and brief explanations on the EU white paper, the CVD investigations, as well as the joint statement where we can clearly see that probably from a legal standpoint, there could be a possibility of developing a new jurisprudence than we already have under the SCM agreement right now. And clearly, there are effects of the EU white paper if the regressive measures under the modules become a reality. They can clearly have a direct effect on the FDI which EU countries may start receiving from non-EU countries. So thank you, Dr. Vermas, for your presentation. We now turn to Professor Vijay Das. He's the head at the Center for WTO Studies. Professor Das, in the joint statement, we've seen the US, EU, and Japan make proposals to include more types of subsidies as unconditionally prohibited subsidies. If this becomes the basis of the new subsidy regime, what are the additional areas which should be part of the new subsidy regime to kind of strike a balance between not just between amongst the entire WTO membership? Can you please share your thoughts on that point?
Thank you, Satvik. At the outset, let me thank CTIL for organizing this session and putting me in such an illustrious company. Thank you, James, for this privilege. I'm going to talk briefly on two aspects. One is certain striking features of the trilateral statement, and second is, with due apologies to Arthur Conan Doyle, the dog that didn't bark in the Hound of Baskervilles, some aspects on which the trilateral statement is silent. So I would like to flag three important elements in the trilateral statement. One is that on the issue of public body, the trilateral statement clearly seeks to repudiate, seeks to go against the grain of the jurisprudence which has emerged. And I would just like to quote over here that what the trilateral statement says is to determine that an entity is a public body, it is not necessary to find that the entity possesses, exercises, or is vested with governmental authority. Clearly, the trilateral statement seems to be veering towards or bending to the wishes of the United States. In quite a few disputes at the WTO, United States was of the view that government ownership itself is determinative of it being a public body. So what the trilateral statement seeks to do is to go against this very sensible jurisprudence which has developed. The second point is that certain aspect of the trilateral statement appears to be old wine in new bottle. I am very specifically referring to the proposal to reverse the burden of proof for subsidies that, within quotes, lower input prices domestically in comparison to prices of the same goods when destined for exports. Now, those of you who've been following the developments in the Doha round, European Union had a very expansive proposal on dual pricing and pricing of natural resources, where they sought to prohibit certain types of practices related to dual pricing. And effectively, it was aimed to achieve this objective. Countries which are rich in natural resources must be prevented from leveraging their natural advantage from providing the raw material for value addition, higher value addition processing within the country, and instead, when they export it at higher prices, something like a reverse dumping. So what the trilateral statement does is it resurrects this entire proposal of the European Union, puts it back on the table, but thankfully, instead of prohibiting it, they merely seek to reverse the burden of proof. Thank God for such small mercies. The third small comment I have on the trilateral statement is that it introduces a very, I would say, a pernicious concept in the subsidies agreement, the concept of hinging rules on subsidies and countervailing measures as well, on capacity. If we look at the subsidies agreement carefully, as well as much of the disciplines in the WTO agreements, the concept of capacity is missing. We have production, we have trade, But capacity as a concept in subsidies agreement is something which I find extremely troubling, because what would really happen is that at the pretext of alleging that subsidies for expanding capacities have distorted capacities, who would be more adversely affected? Countries that create capacities after the first movers in the market. Where are the first movers in the market? Mainly in the countries where new technologies get developed. Where are the fast followers? They are not in the countries where new technologies get developed. Mainly the fast followers are in developing countries. In many instances, the developing country governments have to extend financial contribution for creating new capacities. And if government intervention in creating capacities is found to be pernicious, then I'm afraid this is going to be a very, very big blow for developing countries who may want to pursue catch-up policies on the path of industrialization. Linked to this third comment is my other concern on the trilateral statement, the dog that did not bark. The trilateral statement is troublingly extremely silent on a vast array of subsidies that are prevalent in some of the largest economies of the world. And when I say some of the largest economies of the world, I am not referring to China. I'm referring to some of the proponents of the trilateral statement. They want to bring disciplines on subsidies that distort capacity. What about creating disciplines on direct government intervention, government support, government subsidies for creating new capacities? Why should there be a distinction between subsidies that create new capacities for new products, for new technologies, and subsidies that create capacities for existing products and existing technologies? I find this absolutely unacceptable. Let me give you a few illustrations of how governments in many of the largest economies have been historically actively involved in creating new technologies, facilitating their dissemination, and not only that, governments in many of the largest economies are actively involved in creating as well as shaping markets for new products. Of course, one view could be that such interventions are necessary for fostering innovation. However, a contrary view could also be that these interventions create an extremely uneven playing field for developing countries. Let me give you a few illustrations of the very, very active role which governments in some of the largest economies have been playing in creating new technologies, in dissemination of the new technologies, in commercialization of new technologies. In a government of a developed country, it has played a leading role, not only in early stage research, but also at the commercial viability stage. Let me share some numbers with you. And these are not numbers which I draw from out of the thin air. Those of you who might be interested in reading a fascinating book by the wonderful professor at the UCL London, Mariana Mazzucato, she has fantastic chapters on how governments, particularly in the United States, have very, very actively intervened in different stages of technology development, and the type of interventions are no different from what is described as financial contribution, thereby conferring a benefit. To give you some illustrations, government programs within the Department of Commerce of a particular country has provided up to 20 to 25% of the total funding for early stage technology firms. There's another research which says that government funding for early stage technology firms is at least equal to the total investment by the business angel investors. The same study goes on to say that this is about 2 to 8 times, mind it, 2 to 8 times the amount invested by private venture capital. Many of the most innovative young companies in some of the largest economies were funded not by private venture capital, but by public venture capital, behind which lies the invisible arm of the government. Let me take you in a different direction. Many of the most promising new drugs trace their origins to research done by tax-funded initiatives. If you were to believe the study by Lazonik and Tulum, the National Institutes of Health spend more than $300 billion for drug development, thereby absorbing a huge cost of the drug development. And the interesting thing is, all these publicly funded research, which leads to new products, the subsidy is not required to be returned. Not only that, the patent which gets created through the public funded research, the private entity retains entire rights over it. To give you yet another example, the molecular antibodies, which provided the foundation for the biotechnology sector before venture capital moved into the sector, was almost completely based on research undertaken by public medical council labs in another developed country. If we look at some of the developments in renewable energy in the solar sector, on both the supply side as well as the demand side, governments have been intervening very, very actively. On the supply side, what we are seeing is subsidies being given by the federal government, by the provincial governments, in forms of grants, tax aids, investment in factory construction, subsidized loans. On the demand side, the state also forges demand, creates a market for the products by again granting tax concessions to the consumers, and interestingly, through huge government procurement contracts. In other words, the manufacturer of the new product is able to underwrite much of his costs because he has an assurance of a huge procurement by different arms of the government. So I would very strongly recommend that those of you who are interested might find it worthwhile to read this book by Mariana Mazzucato called The Entrepreneurial State. Now, in the same vein, we have another researcher, Fred Block, who comes up with a very, very interesting finding. He says that government funding played a key role in technologies in as diverse fields as computers, jet planes, civilian nuclear energy, lasers, biotechnology, etc. And if we were to believe the research by Fred Block, then an office in the Defense Department of one of the largest economies in the world helped firms get to the stage of commercial viability. This required this agency to provide firms with assistance that went well beyond research funding. And this model encompassed targeting of resources, technological and business brokering, and some bit of facilitation. The short message is very clear. Governments in some of the largest economies have played a very active role through grant of subsidies in creating new technologies, in dissemination of new products based on these new technologies, in creating markets for these new technologies. So why shouldn't the new subsidy regulation, if at all we are contemplating that, address these issues as well? Why should it just confine itself to addressing distortions of capacity on account of subsidies? Let me conclude by just quoting what Fred Block says in one of his very interesting articles. Let me quote, "The constant message of the Washington Consensus has been that other nations must pull the government back from playing an active role in the economy. But as we have seen, the real Washington has become ever more deeply immersed in their own business economy through its technology policies," unquote. And when I talk of technology policies, essentially it is creating new technologies through active subsidization by the government. So let me stop over here. Thank you, ladies and gentlemen, for your very kind attention. Thank you, CTIL, for giving me this opportunity of being in this very illustrious company and sharing my thoughts.
Thank you, Professor Das. It was really great to hear from you how countries actually look at subsidies from different lenses, depending on whether they are the governments which are giving subsidies to their domestic industry, or there are other countries doing the same for their domestic industry. And also an interesting point which you raised was the difference between creating new technologies and products and the subsidies given for those purposes versus the subsidies for existing products and technologies. I think that point is worthy of a separate discussion altogether. And thank you for sharing the work of Professor Mazwakatu with us, as well as Fred Block. It will be really fascinating for us to read their works. Thank you, Professor Das. I believe Professor James has a few comments on the points which were raised, and I would ask Professor James to kindly give his inputs right now. Sir, you're muted, sir. You need to unmute the system. Thank you, sir.
Same order, let Anuradha speak, and after that I will come.
Okay, sure, sir. So thank you, Professor Das, for your presentation. Now we have Ms. R.B. Anuradha with us, and Anuradha ma'am, we are really delighted to have you here. We would like to hear your views on the trilateral statement by the US, EU, and Japan, and in the entire bigger picture of rebooting the WTO, which is actually the theme for this Geneva Trade Week session. Where do these proposals on subsidies through trilateral statement fit into the bigger picture of rebooting the WTO? Can you please give us your thoughts?
Thank you, Satvik, and thank you to James, to CITIL. It's a privilege to be part of this panel. Let me begin with the World Trade Report of 2006, which was dedicated to subsidies. It explained that the starting point for the economic analysis of subsidies is a benchmark economy featuring perfectly competitive markets. The theory being that under the condition of a perfectly competitive market, there can be no case for a subsidy. It then went on to note that introducing a subsidy or some other government measure within a perfect market framework will be inefficient and welfare diminishing. And then continue that if the perfect market assumption is relaxed, situations may arise where a government measure like a subsidy improves welfare. It then tried to find out, what would be the characteristics of an efficient subsidy, and said and explained that an efficient subsidy would be one that would correct a market failure and bring social and private costs and benefits into perfect alignment. The report thereon, however, struggled but failed to identify, in my view, how such a perfect efficiency would be achieved. And I think the reason for that is because there really is no one-size-fits-all framework. The choice of what is efficient, what is not only an economic one, it is a political one, it is a problematic solution that can actually evolve. But what is clear is that when government intervenes, policymakers will pick certain beneficiaries. Those beneficiaries will have a competitive advantage over those who cannot receive the subsidies. Now, in that context, when I look at the trilateral statement that US, EU, and Japan have brought out, it seems to me that, as again Abhijit has explained so well, it targets specific types of subsidies, as your own concept paper, Satvik, brings out pretty clearly. These are phrased in absolute terms. They are silent about other forms of subsidies. As you explained, it envisages a new category of prohibited subsidies, which will include unlimited guarantees, subsidies to an insolvent or ailing enterprise, absent a credible restructuring plan, subsidies to enterprises unable to obtain long-term financing, as Abhijit pointed out, in sectors of overcapacity, certain direct forgiveness of debt and excessively large subsidies, and so on. Interestingly, the trilateral statement is completely silent on the issue for a need to relook the existing disciplines under the ASCM and those categories of permitted subsidies, which, as you have also pointed out in the concept paper for this session, have benefited only developed countries. The concept note for this session has addressed the issue of the safe harbor under the ASCM for export credit schemes that fall under the OECD arrangement, which clearly has benefited primarily developed countries. The US EXIM, for example, is one of the biggest beneficiaries of having been able to promote such schemes. Countries like Brazil, India, China have really not been able to utilize it. So there are critical questions in terms of what are the new types of export credit schemes which need to be safeguarded, for which countries should have some kind of a policy liberty, whether newer realities, for example, you point out the issue of short-term credit, which is fairly prevalent, whether that needs to be given some kind of a dispensation within the current arrangement. The basic point that I want to highlight is that it's not sufficient to talk about new disciplines in isolation. We need to look at whether existing disciplines are sufficient, whether they need to be restructured, whether there needs to be reform. Abhijit has pointed out certain very, very critical examples of the type of subsidies, in a sense, direct, indirect, hidden subsidies that are very, very widely prevalent. And again, this is a growing reality. I mean, government support, whether as a welfare enhancing function or as a rescue operation for certain domestic enterprises, is certainly a growing reality everywhere. There is, of course, the older debate that developed economies got to where they are by infusing and availing of massive subsidies. But forget that. We have to talk about the kind of subsidies that exist today. So to add on to some of the examples that Abhijit pointed out, we have, as of the last couple of days, there is news of the Nippon Telegraph and Telephone Company in Japan, which has made an offer of $40 billion to purchase all shares of its subsidiaries and mobile phone unit of NTT Docomo at a 40% premium. It is also widely reported, although effusively denied by NTT, that the deal was promoted under pressure from the new administration in Japan to lower mobile phone charges. It's a fact that the government is NTT's, that is the Nippon Telegraph and Telephone Corporation's largest shareholder, owning around 34% of the corporation as of June. Question simply arises, is there a subsidy element? In the EU, in the US, worldwide, we are talking about the pandemic bailout packages. In the EU, for example, the bailout package, I understand, has a slightly larger share. The $750 billion package has a slightly larger share for grants rather than loans. So again, where is the subsidy element here? And how is that being acknowledged and addressed? In the US, we have umpteen examples of bailouts, whether it was the auto industry bailout, not just in the 80s, but again, in 2008-9, the financial sector bailout in 2008, the current COVID bailout package exceeding $2 to $3 trillion and its possible expansion. And there are various numerous analytical pieces which question whether these packages had only a welfare enhancing function or they actually resulted in enriching a few, which is the subject of a lot of critique and fair amount of debate on this area. And a similar outcome, whether a welfare result is what is going to be achieved by these bailout packages in the context of the pandemic, or whether it would actually be something of a benefit for select players, that's again something which remains to be seen. Let me emphasize at the outset that we need to relook at subsidies. There's absolutely no doubt about that. There is a need to refine, to engage in the debate. But my biggest problem with the trilateral statement is that it appears to seek to demonize some sort of subsidies while allowing other not very efficient instruments to continue. In its current form, therefore, I do think that the trilateral statement runs a very serious risk of skewing the debate somewhat. The other dimension was this issue of reversal of burden of proof, and then it also manifests itself in the trilateral statement in the context of anything that is not notified under Article 25 will be presumed to be a prohibited subsidy, which raises the fundamental issue in terms of the value of notification. Certainly has a tremendous value in terms of promoting transparency, but can it really reverse the burden of proof in terms of who has to establish that the subsidy exists? The current format under Article 25 of the ASCM also envisages a robust request for information mechanism whereby any member that has any doubt can actually ask for the nature and extent to which a subsidy is maintained, for an explanation on reasons why a specific measure has not been considered fit for notification. The reversing that burden, in my view, can have serious consequences for the balance of rights and obligations. Even under domestic law, for that matter, non-notification, except in very limited circumstances of, say, income tax or any other sort of serious instrument, doesn't really have criminal consequences. It's typically subject to civil liability or fines. So in that broader context, to overplay the notification requirement, which has a critical role, no doubt, but whether it can be elevated to non-notification resulting in prohibited subsidies is certainly a question worth debating further. And then this takes me to one of the last points that I want to make is on the issue of subsidies for services, on which the trilateral statement is completely silent. Subsidies for investment made in foreign countries in the form of acquisition of shares or takeover of enterprises is an issue that the EU White Paper tries to address and completely acknowledge Edwin Berman's points that he made in terms of how skewed some of the suggestions are in terms of creating a discriminatory impact. But the point that I really wanted to move on to and emphasize is that disciplining for subsidies in the services sector has been a non-starter, despite a very clear mandate under the GATS that members should develop disciplines for subsidies for services. And the linkages, in my view, are particularly crucial today, with servitization being hailed as the new manufacturing model. Bundling of digital technologies with products to create new service offerings. For example, it's been envisaged that in the aviation sector, over 50% of revenue relating to engine OEM is from services, 40% in the case of automotives, 20% in the case of industrial equipment and medical life science equipment. So in this scenario, to neglect a discipline for services is only going to mean that this will continue, this will expand as one of those permitted categories, and again, completely skew competition and result in trade distortion. Under the existing disciplines in GATS, yes, to a certain extent, discriminatory subsidies in sectors where GATS commitments have been taken by a member are likely to be held to be GATS incompatible. But at the same time, there is a fair amount of lack of clarity in terms of the context for each mode of supply. The scheduling guidelines, for example, do not require national treatment to be provided outside of the territory of India. Let's take a very quick example of funding by international development agencies, for example. We have the Japanese International Cooperation Agency, which is one of India and New Delhi's metro system, for example, has been one of the largest beneficiaries of the infrastructure-related funding provided by JICA. At the same time, any JICA funding is linked to the engagement of Japanese construction contractors and consultants. Is this not the same as subsidized services? So just to conclude, I mean, let's face it, we are 25 years after the WTO was arrived at. We are not looking at a situation of any less government intervention, whether it is developed economy or developing. There are newer forms of government intervention that are evolving. There is an increased perception for the need of government intervention to deliver welfare measures and, in a sense, achieve resilience. So we have subsidies for publicly stated non-trade objectives ranging from national security, cultural policy, etc., some of which were also briefly dealt with under the 2006 World Trade Report. In my view, we need a far more realistic approach to subsidies. Any universal disciplines and principles will have to be carefully designed. It can't have the approach of being selective and targeting subsidies of only a few countries while trying to create carve-outs for others or other type of practices. Because in today's day and age of geopolitical and economic scenario and alignments, in my view, such an attempt will be a non-starter. It is time for an honest and clear appraisal which is underpinned in economic principles while recognizing the role of the state as an interventionist. We have to be innovative and not draconian. Thanks.
Thank you, Anuradha ma'am, for your presentation, which really raises important questions that, yes, the proposals are an attempt to depart from the existing elements of SCM agreement, but the important questions are in what direction is this departure going towards? You also mentioned the important issue about the rescue operations of the governments, in which they would be expected to release certain bailout packages. Where do such packages fit within the newer disciplines of subsidies? And especially during the ongoing pandemic situation, it's a really pressing issue. And even Professor Robert House has actually published an article in Journal of International Economic Laws where he's clearly said that right now during the pandemic is not in absolute terms is not the right time to have a stricter regulation of subsidies, because right now we need to give the governments more leeway to come out with bailout packages or to come out with certain financial contributions to help mitigate the effects of COVID. So that's a wonderful point which you've raised, Anuradha ma'am. Thank you so much for your presentation. We would now very quickly move to Professor James, and so it would be great to know from you to what extent the far-reaching effects of such the proposals in trilateral statement and also the EU white paper along with the CVD investigation and the expected negotiations in the International Working Group on export credits. What are the far-reaching consequences which this could have for the entire WTO membership, as well as are there going to be different consequences for different countries depending on their development statuses? So.
A huge thing. But at the same time, I think we have to really look at this matter. So Anuradha mentioned that subsidies have got a major function in terms of creating positive externality and also in terms of preventing certain kind of market failure. And Professor Abhijit Das also mentioned about the kinds of support which are actually given research and development to various sectors in order to prop up or maybe to give a kickstart to a particular sector. So we know that, I mean, if you look at, the timing of the proposal, I mean, when I looked at the timing of the proposal, it happened on the 14th of January. So in all likelihood, it happened before the coronavirus actually had its tremendous impact on the world economy. So my feeling is that perhaps in August or September 2020, we are discussing this trilateral proposal at a very wrong time. But if you look at the systemic issues, the larger issues governing the subsidies and countervailing measures agreement, we have to understand that it is still a piecemeal legislation. If you really go back to the history to 1947-48, in the gap there was no specific provision for dealing with subsidies. We only had this nullification and impairment provision. We are very familiar with the Australian ammonium sulfate case. So that too all came under the nullification and impairment matter. The Tokyo round provided certain kind of disciplines, but again, if you look at the recent developments, a large number of government funding, especially in certain areas where the government has got a predominant role and share in the functioning of the market, some subsidies can have a deleterious impact. There's no question about it. And maybe we are also talking about the Chinese issue here, and we can't actually hide that particular matter. But at the same time, I fully agree with all the panelists here that while this particular statement may be targeted at China, the other developing countries or least developed countries can also feel a bit uneasy about it. Because most of these economies also provide some kind of a support, which may be sometimes a support to an ailing industry, sometimes a support given for a company that is yet to be closed down. To explain this point even further, in a country like India, it is very difficult to even shut down an extremely ailing establishment because of some labor regulations. So although this particular proposal may be targeted at China, we have to understand that it may have a larger implication for the entire WTO membership. Now, when we really look at the specifics of this measure, so we know for sure that at the moment only two categories of subsidies are per se considered to be prohibited. They are the export subsidies, and the second is the import substitution subsidy. The question that we should definitely ask is, when we think about these four categories of subsidies, which is one is unlimited guarantee, then the subsidy to an ailing or insolvent firm, then the third is subsidies to enterprises unable to obtain long-term financing or investment, independent from commercial sources. We have to really think whether these categories of subsidies actually qualify or they are good enough to be prohibited. In that area, I tend to agree with some of you that the existing disciplines of the subsidies agreement to an extent already deal with the situation. So some of you might have actually read the Korea Commercial Vessels decision. So where the Korean Kixin Bank was actually granting loan guarantee. And in that particular case, the panel said that the impact of the guarantee is to provide unlimited amount of support, unlimited amount of guarantee. And we are also very familiar with sometimes some programs run by countries, including the European Union. The very famous case of the Airbus, in the large aircraft decision, the WTO appellate body also concluded that without the launch aid or without the MSF support given by the European Union, the A380 and A320 aircrafts would not have been launched. So in a way, I think it is a reality that all the countries are actually providing it. So one interesting issue is if the European Union is providing these categories of subsidies, if the United States is providing it, if many other countries are providing it, what is actually the rationale behind this trilateral statement? So my feeling is that if it is basically to deal with a number of pending issues with respect to the SCM agreement, it is a good thing. But if you're going to only target a particular country in the garb of this trilateral statement, then we may not achieve much. And there are a number of problems which are actually related to the SCM agreement. One major problem is basically with respect to the lack of exemptions. So all of us know that the category of actionable subsidies, non-actionable subsidies are not there in the SCM agreement. It actually expired in 2001. And secondly, a large number of government would like to promote green energy, sometimes some of the sectors which are actually good for carbon mitigation or carbon adaptation. And these subsidies again will sometimes fail the provisions of the WTO agreement. So there is actually a case, there is a clear case for providing some kind of an exemption or resurrecting the category of non-actionable subsidies under the SCM agreement. Another major concern is that the GATT disciplines, basically Article 20 of the GATT, do not apply to the SCM agreement. So if there is a violation of the SCM agreement, like in the Canada renewable energy case or in the India solar case, it is, for a subsidy violation, it is very difficult to go to Article 20. We have to also realize that in modern times, many countries would like to promote certain sectors, maybe based upon national security grounds. Now, let me give an example of 5G or maybe some other sector for that matter. So in those situations, a country would like to actually use a national security exception or maybe a general exception. And that kind of an availability or possibilities is not there in the current SCM agreement. So when we really look at the current scheme of the SCM agreement, there are many areas where reforms and certain kind of amendments are badly required. So now let me also talk about one of the other important issues which the trilateral statement addresses. So Anuradha also mentioned that the reversal of the burden of proof is a major issue. I agree. Because lack of notification or non-notification of a particular subsidy in many situations, may not be a very carefully chosen decision. It may not be deliberate at all. It may be sometimes an oversight or sometimes negligent action. And we can't actually put all the burden on the state that provides these kind of subsidies to come and defend themselves in a WTO matter. So this is why I think the trilateral statement, according to my understanding, is only a statement of intent that in certain areas there has to be certain reforms with respect to the SCM agreement, and the details are not actually spelled out in great care or in great detail at the moment. They have to be worked out. And that is why I think rather than completely opposing this trilateral statement, it is important for even developing countries to examine the contents of the trilateral statement and find out what can be achieved by proactively participating in the statement. So one important question is actually the issue of input dumping, or not input dumping, dual pricing. At the moment, I think even the European Union is involved in many cases where input dual pricing is a major issue, mainly with respect to certain fertilizer products and other items. The disciplines under the anti-dumping agreement may not be good enough to deal with the situation, because when you actually initiate an anti-dumping investigation, of course you tend to ignore the cost and price in that particular country, and then use some kind of a surrogate price. So anti-dumping may not be the best mechanism to deal with the dual pricing situation. But it is also a factor that certain countries which may have a natural advantage in one particular area, and they may through a government exercise of power provide certain kind of mandated price in the domestic market, and they would like their exporters to export at the international price in the foreign market. So these are all problems actually which need to be at least discussed in the WTO. The one problem which I also wanted to talk about is the creation of excess capacity. So if you look at traditionally, if you look at the problem of excess capacity, it has happened in some of the commodity sectors. To give an example, in the steel sector or maybe in the aluminum sector. And these sectors are also susceptible to the boom and bust over a period of time. So if I remember correctly, there was a similar initiative in 2006, in 2005, around the time in OECD. Professor Abhijit Das already, participated as India's negotiator in that discussion. So I feel that, we can say that the elements of the trilateral statements are extremely nebulous and vague at this moment, that they cannot be subjected to detailed disciplines under the WTO. Even the fisheries subsidies is actually a new area where countries are trying to identify the categories of illegal subsidies or subsidies which can lead to excessive capacity. So if we can find a solution with respect to fish subsidy, I think we should also be able to find a solution with respect to industrial subsidies, which may affect the commodity sector. The next important point which I just wanted to highlight is the issue of public body. I know it's an extremely important issue in the WTO, and many countries have actually lost their CVD actions based upon some kind of a finding by the WTO panel or the appellate body. Again, I think, so you referred to an article by Robert House, and Robert House also has given some kind of a comment on the interpretation of the term public body by the appellate body, whether it was appropriate to use the principles of the International Law Commission's articles on state responsibility to interpret this term. The term public body it's actually part of a lex specialis. It has got a particular meaning within the SCM agreement. So I think when countries actually join these kind of agreements, they may have a certain kind of a notion as to what is a public body. And I also believe that judicial interpretation is not a good way, to do some kind of a gap filling. And sometimes when some certain judicial rulings can create certain problems, then it is the responsibility of the members to talk about these matters, maybe through a formal discussion or negotiation. So to that extent, I feel the trilateral statement may be a good opportunity. I'm not talking about the timing at all, because I feel these are bad times to really engage in any kind of good, a good faith negotiation. But we should at least highlight these matters for some kind of a reform in the future. The last point which I want to mention is on export credit. Again, export credit, as we know, I mean, with respect to export credit, there's a special provision under the ACM agreement annex in Annex 1 Item K. And if a country wants to defend some of the export credit policies, then it has to come within the folds of the OECD agreement, the OECD arrangement. But unfortunately, the OECD arrangement is dealing only with long-term export credit. And we know that short-term export credit is extremely important. A large number of developing country exporters do not have access to capital. And there's very high inflation in those countries. The risk to getting capital is actually very high. So in those situations, I think in order to provide a level playing field to the developing country exporters, their mechanism has to be also brought within one of the successor agreements. So now there is an initiative under the International Working Group on Export Credit. But even to my understanding, that International Working Group on Export Credit is not dealing with short-term export credit, it is actually dealing with the long-term export credit. So these are areas where there has to be a greater effort at the international level in order to involve the participation of the developing countries. Because at the moment, export credit is a huge issue. According to some studies, the European Union itself provided around $60 billion of export credit during 2019. And more than 80% of the international trade is actually financed through some form of an export credit. So there has to be a viable mechanism, there has to be a successor agreement, and the successor agreement will have to definitely reflect and accommodate the concerns of developing countries. It is extremely important for that direction. The last point, is slightly, again, I mean, if you look at the ACM agreement, there are multiple issues actually. The one is definitely the benchmark determination. So we are very familiar with cases like the softwood lumber case, or maybe the India carbon steel case, where some natural resources are completely owned by the government. So when the natural resources are completely owned by the government, it is technically possible to argue that there is no market in that particular country. The ASEAN agreement is actually more liberal than the anti-dumping agreement to that extent. It says that in order to find out the prevailing market condition, you can even go outside the country. But let me tell you, in certain areas, especially natural resources, it is always difficult to find out the prevailing market rate, and especially in the context of natural resources, there is also an argument that the calculation of the prevailing market price should take into account only the factors of production and not the rent. So this is a very important argument. So if you also take into account the rent associated with the natural resources, it can basically distort or skew the calculation of the prevailing market price. Again, this is one area. Then there are many other areas as well. The second issue is the determination of specificity, especially with respect to de facto subsidies. So I don't want to actually go on and on, but these are some of the real issues which need to be tackled at some point in time. Maybe once the COVID situation is over, I think the WTO membership, with an open mind, try to address these matters, and if possible, find certain solutions. Thank you, Sathu.
Thank you, James, sir, for your thoughts. There are clearly pressing issues which we need to consider when analyzing in the direction in which the proposals are going, and whether or not the trilateral statement really addresses the concerns which should be addressed at the first instance. So now we turn to Dr. Vihan Zhu, who has been patiently listening to all the panelists. Dr. Zhu, it has been suggested clearly that the proposals are targeted towards the Chinese state-owned entities. So we would like to hear your thoughts on what are the implications of these proposals, as has been raised by other panelists, on other countries, not just China. And is the assumption or allegation that these are China-specific issues and China's WTO plus obligations are inadequate? Are these allegations or assumptions really, do these allegations have substance, or these are really erroneous? So we would like to hear your thoughts on that.
thanks, Satwik, for the kind introduction and for the question. And thank you for the CTIL and James for inviting me to this important conversation. And actually benefited a lot from my panelists have talked about some of the very important legal and specific issues, and also talk about some of the fundamental and rational level issues. I don't when I was actually preparing for this conversation, I was trying to talk about the legal and specific issues as well. But now with all of the panelists have given their thoughts on the very important issues, I have kind of decided to change my approach a bit. So what I'm going to do here is just perhaps giving a very high level and macro level, if you like, concluding remarks on what we have been talking about, but also trying to respond to your question. So I'm talking about three. I divided this into five things that we need to think about when we think about the future of subsidy rules. The first thing is the reality. As my fellow panelists have also talked about, I think the reality is industry policies and subsidies have been widely used by all major trading nations for a variety of regulatory goals. The pandemic has made such policies and subsidies even more crucial for all nations affected. So it is only reasonable to predict that such subsidies and policies will continue to be used in ways that serve regulatory objectives and preferences of individual nations after the pandemic. So I think the negotiation is to take into that reality, and that reality will become one of the fundamental facts in the continuing negotiation after this crisis. And the second point I want to make is about the economic rationale, and I think my fellow panelists have also talked about. I think subsidies are usually an economically preferable instrument to address a domestic market failure or externality. And in many occasions, in fact, the first best instrument. The WTO does not restrict members' choice of policy objectives, but does try to discipline the choice of policy instruments. If we understand the function of the WTO as one that discourages the use of less efficient measures in pursuing a given objective, then the regulation of subsidies must seek to achieve a balance in addressing the trade effects of subsidies, but not unduly restricting the capacity of members to use an optimal policy instrument such as subsidies to achieve a chosen objective. So that's just a broader point I want to put on there about the rationale we need to think about when we think about how to regulate subsidies. And then the third point is about the political compromise. Trade negotiations do not produce the best economic outcomes, but typically reflect a desirable political compromise at the time of the negotiations. The current subsidy rules came out of such a political compromise, which was achievable at the time of the ULV round. This compromise essentially centered around a few major competing interests, including, on the one hand, the protection of the value of tariff concessions at the time, and the discipline of trade distortive subsidies, and on the other hand, the widespread and persistent need to use subsidies for all kinds of regulatory goals, and the disciplining of the abuse of countervailing measures against legitimate use of subsidies. Arguably, these competing interests remain in the current negotiations. That is the demand for more stringent rules on subsidies and more flexibility for the use of countervailing measures to address the trade effects of subsidies, and the need for policy space for the use of subsidies to address regulatory goals. So I think a multilateral consensus cannot be achieved without a balanced approach to the regulation of subsidies that reflects these key competing goals. This point has also been considered by my fellow panelists in the previous conversation. So now let me turn to the fourth point, which is the proposal. The proposal provides no detailed explanations as to the various prohibited programs and the rationale behind it. I think that has also been noted well by my fellow panelists. On the face of it, it seeks to strengthen the subsidy rules without paying due regard to the competing interests, which is the policy space. So in this sense, I think it is biased towards more and heavier regulation losing sight of the needs for policy space. As such, I think it's unlikely to be a modality that could generate consensus. Now, if I can go into a little bit detail in some of the weaknesses in the proposal, which I think my fellow panelists have also covered. I think let me just look at perhaps two examples. The first is if one looks more closely into the prohibited subsidies, the proposed ones, one would actually fail to see any justification or rationale behind the proposal. For example, why the list is limited to the guarantees? Why is the criteria for being selective relating to certain direct forgiveness of debt? What does certain cover and why? So those kind of uncertainties there, it's really hard to justify why these should be prohibited subsidies. And the second, perhaps just let me also touch upon the reversal of the burden of proof. I think this is problematic. If the issue is lack of transparency and difficulties in collecting evidence, then what needs to be done to reduce such difficulties is to encourage notification or otherwise reduce the prima facie evidential requirement for a complaint to show the existence of such subsidies. It's not the reverse of the burden for the complaint, for the subsidizing member to show the trade effects of the subsidies. The complaint is in the best position to show the effect, whereas the subsidizing member is in the best position to show that the subsidy does not exist. So I think we need to kind of reconsider the reverse of the burden of proof. I think now let me perhaps just come to the point about China. I think this is perhaps the worst part of this. And this is, as we all know, this is not really the only trilateral joint statement. There have been several before this trilateral joint statement, in which the subsidies are proposed. It becomes very evident if you read all of the joint statements, the proposal targets China based on the allegation that the existing WTO rules are inadequate. I think there are two general problems there. The first is subsidies are widely used, while only those used by China cause a problem. So that's the first thing we need to think about. And if one considers the WTO disputes over subsidies, the most significant and difficult ones, as James also mentioned, do not concern China, but other WTO members, notably the parties to the joint statement, such as subsidies to national champions in the aviation industry, to key players in the semiconductor industry, and the use of abuse contravening measures to protect domestic soft lumber industry. So those do not involve China. The question is why these subsidies should be excluded from future negotiations of subsidy rules. And more fundamentally, I think, can a proposal or modality that targets subsidies in some countries but excludes subsidies that have similar trade effects in other countries be acceptable to WTO membership? Should it be accepted? So I'll just put these questions there. And the second problem is the allegation of existing rules are inadequate to deal with China. I think that's untenable. But let me just say that I think whether the existing rules are adequate to deal with China's subsidies requires a careful discussion of the legal standards contemplated in the subsidy agreement and also the WTO jurisprudence. In light of the subsidies we're actually dealing with, there has been no studies. I have actually looked at most of the studies, and those studies actually listed out the Chinese subsidies in, for example, the high-tech sectors that could actually not be covered or dealt with adequately by the SM agreement. Now, this discussion must also take into account the China WTO Plus obligations. And there have been many very significant and broad China WTO Plus obligations that have never been used. So the question here, I think, is not really the lack of rules, but the underutilization of the rules, particularly the China-specific ones. Now, we had a paper published a couple of years ago, basically looking into the issue of public bodies and SOEs or subsidies provided by SOEs, whether SOEs can be actually treated as the public bodies under the existing jurisprudence. And I think James also mentioned. And the conclusion is that given the current SOE reform in China, it has become easier to establish public body than before. But even if one considers the two cases involving China, the panel body developed and applied the authority-based approach. In both cases, the panel body was able to support the funding of public bodies of Chinese SOEs. And finally, I think the final point is, let me just come back to the reality and also to kind of reflect on the pandemic. I think we need to think about the fact that the pandemic is not the root cause of the fundamental and the systemic challenges we are facing today in the world trading system. Thinking about industry policies, subsidies, and more generally, state capitalism, non-market economies, market distortions, protectionism, unilateralism, and so forth. These challenges for international cooperation on trade rulemaking and dispute resolution predate COVID and will persist after it. So I think dealing with the pandemic or the measures associated with it would not provide a satisfactory nor sustainable solution to these challenges. Instead, as I flagged earlier, the solution needs to be a collective action and a balanced approach. And in this regard, this needs to be a common belief that economic nationalism and protectionism is inferior to international cooperation as a way to overcome the ongoing crisis and trend of deglobalization. And finally, when it comes to subsidies, I think future development of international subsidy rules must not narrowly target China, must be pursued through international cooperation and reflect the shared interests of all nations involved. Yes, Chinese subsidies have exemplified the challenges of international regulation of subsidies, but any further development of the multilateral rules will need to be facilitated by and will apply to all WTO members. And thanks again for the invitation. I'll stop there.
Thank you, Dr. Zhu. We really are almost out of time. I've been told that we can just have 3 minutes or 2 minutes in our hands. So we are unfortunately able to take just one question right now from the audience. There have been many questions from the audience. So that it really means that all the panelists have really given a lot of fodder for the participants to feed on and think about. So we'll take just one question, and any of the panelists are free to answer this question in as brief manner as possible. The question is, given the new proposals, does the size of the subsidy and the structure of the subsidy really matters when countries would start to adhere to the proposed prohibited subsidies or proposed subsidies which should be brought within the scope of ASEAN agreement? How can the structure and the size of the subsidy really play with the new proposals? Any of the panelists can feel free to answer this question very quickly.
Okay, Satvik, let me try.
Sure, sir.
Size certainly can make a difference, but it cannot be an absolute number. What may be a small subsidy in a large economy, let's say European Union or United States, may be a very huge amount for me. So the size issue has to be relative. Relative to what? That is something we have to think about. So that was my 2-bit on size.
Thank you, Professor Das. Professor James, I think you have some comments. You can unmute yourself and just very quickly.
I just wanted to mention that size is actually a definitional matter. So Professor Das has already responded to that question. We can always find out, some kind of an appropriate definition for that. For a small economy, it can be defined properly. That need not be too bothersome at this stage.
Fair enough. Thank you, Professor James.
So can I also kind of contribute just very quickly?
Sure.
Yeah. So my answer to that question is that I think size, as other matters, should also go into the consideration of the balance. So how you actually balance the need to discipline the trade effects of subsidies, but the needs of developing and developed countries alike, to use subsidies for certain goals. So I think the size also needs to go into that consideration, and the balance needs to be achieved perhaps not actually on a very general level, like you apply a size to everybody, but you have to take into account the different needs of different countries. So you may have different sizes.
Thank you, Dr. Zhu. So I would like to conclude by really thanking all the panelists to have readily accepted our invitation to share their thoughts here. I would like to thank Geneva Trade Platform for giving us the opportunity for organizing this session. And obviously, lastly and most importantly, all the participants who've been able to attend this session, raise their concerns. We really apologize that because of paucity of time, we couldn't take all the questions. If you have questions, you can feel free to contact CTIL and drop an email of your questions, and we'll try to forward them to the panelists and try to get your answers to you through emails after the session. Thank you so much, everyone, for joining us. It was a great interactive session, and there is a lot of fodder to feed, as I would like to say. And we hope to meet again on the grounds of new developments, and hopefully all of our disintegrated thoughts find a way to integrate among themselves, and the WTO membership gets convinced, and there is a consensus amongst the members in the direction in which the subsidy regulations shall flow in the future. Thank you so much, everyone. Have a great day, good evening, good night, and we'll see you soon. Thank you so much.
Thank you.